Hi, my name is Arnaz Hathiram and you're watching Voice for Men India. Starting today, we shall be curating several news stories with regards to anti-men or gender bias laws in India. We shall also try to update you with what's viral on social media along with the current ongoing debates. Do subscribe to our channel and share our videos ahead in case you find value in our content. Let's begin with the first story for the day. The Bombay High Court Aurangabad bench has directed the state police to enhance security at family courts. A gunman or a bodyguard to principal judge at each family court, along with 2 male constables and 3 female constables to be deployed with immediate effect. The decision comes after the High Court noted a rise in incidents of violence and assaults in these family courts, often stemming from high tensions between litigants, some of them who have also resorted to physical altercations or brought weapons. The directive was issued by a bench comprising of Justices V.V. Kankanwadi and Sanjay Deshmukh of the Bombay High Court Aurangabad bench after a PIL was filed concerning the safety and security of family court environments. This PIL highlighted emotionally charged disputes, particularly in marital cases, that led to assaults on opposing parties and their legal representatives. The court had previously taken suo motu cognizance of the issue after multiple assaults on the judicial officers. The Principal Secretary of the Home Department was given 4 weeks to provide an affidavit detailing a security plan. While undertaking progress on the matter, the court noted that reports from the Director General of Police had not been submitted yet, despite a deadline which had already passed on February 7. Emphasizing on the need for better coordination amongst various government departments to expedite data collection, the court has now ordered the Principal Secretary of the Home Department and the Law and Judiciary Department to gather necessary data from all courts in Maharashtra by March 28, and a security policy must be finalized by April 22nd. Now let's move on to our story number 2, which is coming from the Supreme Court. Maternal grandparents can't have better claim than father, even if he has remarried. The Supreme Court in its recent order has ruled that a father's remarriage cannot be a reason to deny him child custody. The top court emphasized that maternal grandparents cannot have better claim than the father, who is the natural guardian. In the current case, the mother of the child had passed away and the minor child remained in the custody of his maternal grandparents. After failed efforts to bring back his son, the father moved a habeas corpus writ petition. The division bench, comprising of Justice B.R. Gavai and Justice K. Vinod Chandran in this matter, were of the opinion that the father, the natural guardian, is well employed and educated, and there is nothing standing against his legal rights as a natural guardian and legitimate desire to have the custody of his child. In earlier proceedings in this matter, a single judge had disposed of the writ petition after interacting with the minor child. According to the judge, the child was comfortably residing and pursuing his education at the maternal grandfather's house. The court then also observed that the father had remarried, and thus the judge opined that it would be in the best welfare of the child to continue his stay at the maternal grandparents' home. The father, interestingly, was granted visitation rights to meet his own child regularly on first day of every month at a venue fixed by the jurisdictional station house officer. Now, what is also interesting is that the maternal grandfather had initiated a proceeding of maintenance against his son-in-law, claiming Rs 20,000 per month for the maintenance of his grandchild. The Supreme Court thus observed that in the given circumstances, the custody of the child be handed over to the biological father. Concluding the matter, the bench quoted, "After the child's birth, he was with his parents for about 10 years till the death of his mother. He was separated from the father in 2021 and has been living with his grandparents, who cannot have a better claim than the father, who is the natural guardian. There is no allegation of any matrimonial dispute when the mother of the child was alive, nor a complaint of abuse perpetrated against the wife or the son." Now let's move on to our story number 3. The Supreme Court has acquitted a man in a kidnapping case after 31 years, citing that the girl had then voluntarily resided with him as his wife. The pace of our judicial system is laughable, but no one from the judiciary or any law minister has been able to fix this problem till date. So what was this case all about? On February 13, 1994, a man along with his father and another person were booked on the charges of kidnapping a minor girl for the purpose of marriage. Now, after 3 decades, the Supreme Court has concluded that the girl had voluntarily gone along with him, traveled to various places, and also resided with him as husband and wife at Dehradun. The trial court had acquitted the accused father and the other person, but had convicted the appellant for offences punishable under sections 376, 363, and 366 of the IPC. The man was then sentenced to 3 years of rigorous imprisonment under section 363 of the IPC 5 years of rigorous imprisonment under Section 366 and 7 years of rigorous imprisonment under Section 376 of the IPC. On his appeal, the Uttarakhand High Court had acquitted him on the charge of Section 376, that is rape, but maintained his conviction under Section 363 and 366 of the IPC. It, however, reduced the sentence to 2 years of rigorous imprisonment under Section 363 and 3 years of rigorous imprisonment under Section 366 of the IPC. Now, in 2025, the Supreme Court bench of Justices B.R. Gavai and K. Vinod Chandran noted that the girl was then aged between 16 to 18 years and was very much of sound mind as to what was right and what was wrong for her. Accordingly, now this convicted man was acquitted by the Supreme Court. This particular judgment raises multiple questions on whether the age of consent should be reduced as a law or whether we should still end up spending years and decades to evaluate each case based on its merits. Now let's move on to our story number 4. Married woman can't claim that her consent was taken on false promise of marriage. This is what the Madhya Pradesh High Court has ruled in its recent judgment. Rape laws are meant to protect real victims of the crime, but in the recent years, many women feel that it is their birthright to misuse this law to their advantage. This was a case where a married woman, a mother of 2 children, had accused her married boyfriend of rape after the consensual relationship had gone sour. In the FIR, the complainant woman claimed that the man had promised that he would divorce his wife and marry her, based on which he established a sexual relationship with her. She further stated that the man had backtracked on his promise of divorcing his wife, and thus she was compelled to file this FIR. Justice Bhatti of the Madhya Pradesh High Court rightly observed that this was not a case of a woman being lured into a physical relationship by misrepresentation of facts. He quoted, "The aforesaid judgments of the Apex Court as well as this court postulate that when the prosecutrix is a married lady and therefore her consent for physical relationship on the garb of false promise of marriage cannot be brought within the framework of the consent obtained on the basis of misconception of the fact. Quashing this matter, the High Court ruled that such FIRs are required to be nipped in the bud as the complaint itself at the face value does not indicate that an offence had been committed." Now let's move on to our story number 5. A man files an RTI to know his wife's husband's name and address from her employer. This leaves the Punjab and Haryana High Court completely shocked. In an interesting case, a married man filed a right to information, that is RTI application, to obtain his own name and address from his wife's employer. The petitioner's counsel argued that the government department had failed to provide the personal information of one of its employees. The state, on the other hand, had opposed this, citing that such information was exempted from the provisions under the RTI Act of 2005. Justice Harsimran Singh Sethi of the Punjab and Haryana High Court rejected such an RTI request, observing that the man had not requested any details regarding his wife's official duties, but had instead sought information about his own name and address. Dismissing the matter, the High Court noted, "Nothing has come on record as to why the husband is seeking the information from the department about the name and address of the husband of Veena Kumari, that is to say that the husband is seeking details about himself, which is surprising." Our guest in this matter is men who are embroiled in matrimonial disputes and who suspect that their estranged wives are remarried without divorce. They could resort to such means to establish evidence via the legal route, and thus the man in this case perhaps also wanted to know the name and address of the estranged wife's husband to be revealed officially. Now let's move on to our story number 6. How much alimony did Yuzvendra Chahal pay to Dhanashree Verma? Several cryptic posts by both Yuzvendra and Dhanashree have been going viral on social media. However, the couple was now officially spotted at a family court in Mumbai on February 20th. The duo got married in December 2020, but have been living separately for the past 18 months. The official reason cited by them for separation was the compatibility issues between them. Now, on the other hand, the social media is abuzz with a 60 crore figure paid as alimony by Yuzvendra to Dhanashree. Multiple content creators and influencers have also made several reels mocking the wife. However, after a lot of online shaming faced by Dhanashree, one of her family members has now broken silence. Speaking with Bombay Times, a family member quoted, "We are deeply outraged by the baseless claims being circulated about the alimony figure. Let me be absolutely clear, no such amount has ever been asked, demanded, or even offered. There is no truth to these rumors whatsoever. It is deeply irresponsible to publish such unverified information dragging not just the parties but also their families into unnecessary speculation. Reckless reporting like this causes harm, and we urge the media to exercise restraint and fact-check before spreading misinformation and also be respectful towards everyone's privacy. While a section of mainstream media had earlier reported about the couple's divorce being finalized, Dhanashree's legal representative Aditi Mohan has now clarified in a statement that the matter remains under judicial consideration. She quoted, "I have no comments to make on the proceedings. The matter is currently sub judice. The media should fact check before reporting as a lot of misleading information is being circulated." On the other hand, Chahal had taken to social media and commented, "God has protected me more times than I can count. So I can only imagine the times I have been rescued that I don't even know about. Thank you, God, for always being there, even when I don't know it. Amen." And the next day, Dhanashree too had taken to Instagram and posted, "From stress to bliss. Isn't it amazing how God can turn our worries and trials into blessings? If you are stressing about something today, know that you have a choice. You can either keep worrying or you can surrender it all to God and choose to pray about everything." Now let's move on to the last story for the day. Priyanka Kadam's viral dance. Have you come across this lady named Priyanka Kadam recently? Well, she has been in the news after her dance at a social gathering went viral. But what is so special about this story? Priyanka is currently posted as an assistant audit officer in the Treasury and Accounts Department at Ujjain. But the reason for outrage over her dance performance is because Priyanka had appeared for the State Services Examination in 2022 that was conducted by the Madhya Pradesh Public Service Commission, and she had sought benefit under a disabled quota by providing a certificate of being born disabled. First, let's watch this video. Now, a students' organization in Madhya Pradesh has demanded an inquiry against Priyanka. On the other hand, the lady in question has denied that there has been any kind of irregularity in her appointment, claiming that she suffers from 45% disability due to bone-related problems, though she is able to walk and even dance a little. That's it from me as of now. Keep following us on our social media handles, that is X, Instagram, Facebook and Telegram. The ID is @voiceformenin. You can also read several case orders and articles on our website, voiceformenindia.com. And lastly, do hit that bell icon below to subscribe to our YouTube channel, Voice for Men India, so that you can be intimated the minute we publish a new video. Thank you very much for watching. Namaste. Jai Hind.